Imagine sitting in a courtroom,
Yeah.
just staring at the man who murdered your daughter on a security camera and having to actually fight the prosecutor to save his life.
Yeah, it's almost impossible to wrap your head around.
It really is. Imagine fighting tooth and nail to prevent the state from executing this guy.
Yeah.
And not out of, like, mercy or forgiveness,
Right, no, not at all.
But just because the machinery, the justice system, has become so agonizing, so drawn out, that the only way to save your own sanity is to basically make a deal with the devil.
It's wild. It completely shatters this comforting narrative we have as a society,
Oh, 100%.
Because we're raised to believe that a terrible wrong is committed, the authorities step in, a gavel strikes, and, well, balance is restored.
Right. The good guys win.
Exactly. We view the justice system as this machine designed to dispense closure, but what happens when that exact same machinery, with all its constitutional safeguards and bureaucratic processes, actually becomes like a secondary source of trauma?
And that is exactly what we're going to trace today. It's this harrowing, multi-year legal journey that began with a devastating crime in 2013 and didn't reach a resolution until a really hard-fought life sentence was handed down in 2017.
It's a long, long time to be in limbo.
It really is. And I want to set the mission for you right now, right at the top of this deep dive. Because usually when true crime stories are told, the focus is entirely on the psychology of the perpetrator.
Right, or the forensics used by the detective.
Exactly, yeah. But this deep dive, which is largely based on some excellent local reporting from 104.5 WOKV and News 4 JAX, this is fundamentally about a mother's incredible, unyielding resilience.
Yeah, it's about what happens when the rigid procedural mechanics of the law basically collide with a grieving family's desperate, visceral need for finality.
Yeah, let's unpack this.
Well, to understand the sheer gravity of this family's journey, we really have to ground ourselves in the reality of the incident itself.
Right.
We have to look at the tragic loss of a young woman named Shelby Farah. It is. In 2013, Shelby was just 20 years old. She was working as a clerk at a Metro PCS store located on North Main Street, which is in the Brentwood area of Jacksonville, Florida.
She's just a young woman going to work, doing her job, standing behind the counter.
Yeah, just a totally normal day.
And the specifics of that day are captured with just chilling clarity on the security cameras. A man named James Xavier Rhodes enters the store. He is armed with a gun, and he demands money from Shelby.
And this is where the sequence of events becomes particularly agonizing, I think, because Shelby complied. She did exactly what every law enforcement officer, every security manual tells you to do in a situation like that.
She gave him what he wanted.
She opened the register. She handed him the money. In fact, she handed him the very last bit of cash she had in the store. So the primary objective of the robbery, at least from the perpetrator's perspective, was completely achieved.
But he didn't leave.
Yeah.
I mean, the absolute tragedy of the security footage is that she handed over the cash, and he still shot her.
Yeah.
He shot her 3 times. And this wasn't like a panic fire or a scuffle over the gun. It was described specifically by the sources as an execution-style shooting.
It's just horrific.
A brutal, entirely senseless escalation of violence against a 20-year-old girl who had offered zero resistance.
Which brings us to the background of James Xavier Rhodes. Because his presence in that store on that day, it represents a massive systemic failure.
Oh, absolutely.
Rhodes had actually recently been released from prison prior to this shooting. He had just served a 3-year sentence.
Wait, I need to jump in here because his prior conviction is what makes this so infuriating to me. He served 3 years for what exactly?
Possession of a firearm by a convicted felon.
I mean, you gotta be kidding me.
That was the charge.
So we have a convicted felon who had already proven to the state that he was dangerous enough to acquire and possess a firearm illegally. He serves a relatively short 3-year stint. He's released right back into the community, immediately acquires another gun, and walks into a phone store to commit a cold-blooded murder.
It's the revolving door of the justice system, basically.
The door is practically spinning off its hinges here.
It really forces society to ask serious questions about the efficacy of sentencing guidelines, especially for repeat weapons offenders.
Right.
I mean, when someone serves time for an illegal weapons charge and immediately escalates to armed robbery and murder upon release, it highlights a profound vulnerability in public safety.
Yeah, but for Shelby's family, this wasn't some abstract debate about recidivism rates,
No, of course not.
It was very raw, immediate devastation. And that brings us to Shelby's mother, Darlene Farah.
Her reaction is just, it's incredible.
It really is remarkable in the aftermath of her daughter's murder.
Right.
Because she didn't just retreat into grief. I mean, nobody would blame her if she did.
Right. Totally understandable.
But she immediately went on the offensive, seeking accountability on multiple fronts. She didn't just wait for the criminal courts to deal with Rhodes. She actually went after the environment that allowed the crime to happen in the first place.
Yeah, she filed a civil lawsuit against Metro PCS and T-Mobile.
And the core claim of this lawsuit targets the corporate management, right?
Exactly. Darlene asserted that the management was fully aware the store was located in a known high-crime area, the Brentwood area of Jacksonville, but they completely failed to provide adequate security for their employees.
Okay, wait. I need to stop you there and play devil's advocate for a second, because I know some listeners might be thinking the exact same thing right now.
Sure, go ahead.
A random guy walks in off the street with an illegally obtained firearm and decides to pull the trigger of his own free will. How can a grieving mother sue a phone company for a murder committed by a third party?
It does sound counterintuitive at first.
Right. Like, that sounds like shifting the blame from the killer to a corporation just because they have deep pockets. How does the law actually justify that?
Well, that is the exact friction point of a legal concept called premises liability, and specifically the duty to protect against third-party crimes.
Okay, break that down for me.
So in standard premises liability, if you own a store and you leave like a puddle of water on the floor and a customer slips and breaks their neck, you are liable.
Because I made the mess.
Right. You knew about the hazard, you didn't fix it, someone got hurt. But third-party crime is trickier. The legal test almost entirely hinges on a concept called foreseeability.
Foreseeability, meaning should the company have known this was going to happen?
Exactly. If a business opens a store in a quiet, zero-crime neighborhood and a meteorite of a crime occurs, something totally unprecedented, the business generally isn't liable.
Because they couldn't have seen it coming.
Right. But if a corporation opens a cash-heavy retail business in an area with a documented statistical history of severe violent crime like armed robberies, assaults, the law begins to shift the burden.
Interesting.
The argument is that the violent crime is no longer an unpredictable anomaly. It is a foreseeable hazard of doing business at that specific location.
If we connect this to the bigger picture, it is like operating a retail store that deals in cash in a known high-crime area and choosing not to put up bulletproof glass or hire a guard.
Yeah, exactly.
It's like pitching a tent in the middle of an open field during a massive lightning storm and refusing to install a grounding rod because it costs a little bit extra. You know the lightning is there.
Yeah.
You are essentially inviting it to strike.
And that analogy gets right to the mechanics of the civil claim. Under the law, a corporation has a duty of care to provide a safe working environment.
Okay.
If the risk of armed robbery is foreseeable, the plaintiff, in this case Darlene Farah, argues that the corporation breached its duty of care by failing to implement reasonable security measures.
What counts as a reasonable security measure in this context, though? I mean, where's the line drawn?
That is exactly what gets debated in these civil suits. Is it a panic button? Is it bullet-resistant glass enclosing the whole counter? Is it hiring an armed security guard? Or maybe it's moving away from cash transactions entirely. Darlene's lawsuit was essentially an attempt to alter the cost-benefit analysis of corporate security.
Ah, I see. She is trying to make it legally and financially more expensive for these companies to ignore the safety of the next 20-year-old clerk than it would be to just install the bulletproof glass in the first place?
Exactly. She is using the civil courts to force a systemic change so this doesn't happen to another family.
And this civil lawsuit did reach a resolution, correct?
It did. In 2016, the case was settled out of court.
Okay.
The terms of that settlement were undisclosed, which is, standard practice. Both parties agree to a resolution, and usually there is a non-disclosure agreement attached, which is why Darlene Farah stated she could not speak about the specifics of the civil case.
So in the civil arena, Darlene found a quiet, definitive resolution. The corporate liability side of the tragedy was closed.
Right.
But the criminal case against the man who actually pulled the trigger, James Rhodes, that was an entirely different beast.
Oh, completely.
While the civil case settled, the criminal case basically devolved into an excruciatingly prolonged, highly public legal nightmare. Let's talk about the timeline, because the sheer duration of this is, frankly, a form of psychological torture.
It really is. The murder of Shelby Farah occurred in 2013. The final resolution of the criminal case did not happen until March of 2017.
That is 3 years and 7 months. 43 months of waiting.
Yeah. And when you look at the mechanics of the court system, 43 months is an agonizing state of limbo.
I can't even imagine.
For the family, the grieving process cannot truly begin because the legal system constantly demands their participation. I mean, every hearing, every motion drags them back into the room with the killer.
And we need to look at exactly why it took so long. This wasn't just like a slow docket or a lazy judge. There were 2 massive legal hurdles that completely bogged down this trial.
Yes, very specific hurdles.
Let's tackle the first one. The protracted debate and the endless evaluations regarding James Rhodes' mental capacity to face the death penalty.
What's fascinating here is the tension between the physical evidence of a crime and the constitutional protections afforded to a defendant.
Okay, unpack that.
The Eighth Amendment of the U.S. Constitution prohibits cruel and unusual punishment. Over the decades, the Supreme Court has interpreted this to mean that the state cannot execute someone who lacks the mental competency to understand the nature of the death penalty and why it is being imposed upon them.
I understand the constitutional theory. I mean, a civilized society shouldn't execute someone who is profoundly disconnected from reality.
Right.
But from a layman's perspective, this is where the system feels completely broken. We have security footage of Rhodes planning a robbery, demanding money, executing a witness, and fleeing.
It's all on tape.
Exactly. It takes a certain level of cognitive function to execute an armed robbery. Why does the legal system suddenly grind to a complete halt to debate if he understands what a lethal injection is?
Because competency in the eyes of the law is highly specific and dynamic. There are actually 2 distinct hurdles here. First, is he competent to stand trial at all? That is based on the Dusky standard from a 1960 Supreme Court case.
What does that mean?
Basically, does the defendant have a rational and factual understanding of the proceedings, and can they assist their attorney in their defense?
Okay, and the second hurdle.
Second, is he competent to be executed?
So the defense attorneys are weaponizing these standards to buy time.
Well, weaponizing implies malicious intent.
True.
From a legal standpoint, the defense attorneys are doing exactly what they are constitutionally mandated to do: vigorously defend their client's life.
By any legal means necessary.
Exactly. In a capital case, the defense will pull every single lever available. That means bringing in defense psychologists. It means conducting exhaustive cognitive testing, IQ testing, and neurological scans.
Wow.
It means digging up decades of childhood medical records, school records, and family history to look for any signs of intellectual disability or severe mental illness.
Yeah, every single one of those tests takes time to schedule, right? Time to conduct, time to analyze, and time to argue about in court.
Oh, months and months of time. And the prosecution, in turn, will hire their own psychiatric experts to evaluate the defendant, often administering tests designed specifically to see if the defendant is malingering.
Malingering?
Yeah, that's the clinical term for faking a mental illness or intentionally performing poorly on an IQ test just to avoid the death penalty.
So they basically accuse him of faking it.
Right. So you end up with these massive, month-long dueling expert testimonies. The psychologists are arguing back and forth on the stand while the family of the victim just sits in the gallery, waiting.
And while the psychological warfare is happening, we have the prosecution side of the equation. Because the former state attorney at the time, Angela Corey, was adamantly opposed to taking the death penalty off the table.
Yes, she was very firm on that.
The state was aggressively pursuing an execution.
So you have a total gridlock. The defense is systematically dragging the process out to prove mental incompetence, filing motion after motion. The state attorney is fighting every single motion, refusing to negotiate, demanding the ultimate punishment.
And as if that gridlock wasn't bad enough, we hit the second massive hurdle. Right in the middle of this exact time period, the actual laws governing the death penalty in the state of Florida were shifting beneath their feet.
Yes. This is where it gets really complicated. The structural mechanics of Florida's death penalty were being challenged at the highest levels of the judiciary.
What was going on?
Without getting too lost in the weeds, during this time frame, the U.S. Supreme Court looked at how Florida handed down death sentences, specifically how judges actually had more power than juries in deciding the final sentence, and the Supreme Court ruled that the system was unconstitutional.
Okay, break that down for me, though. How does a Supreme Court ruling in Washington, D.C. literally paralyze a local murder trial in Jacksonville?
When a state's capital punishment statute is ruled unconstitutional, it throws every single pending death penalty case into immediate chaos.
Every case.
Every single one. Because the state legislature suddenly has to draft a brand new law that complies with the Constitution, for example, requiring a unanimous jury recommendation for death rather than a simple majority, or taking away the judge's ability to override the jury.
Okay, I follow.
Until that new law is written, debated, passed by the legislature, and signed by the governor, prosecutors and local judges literally do not have a valid legal framework to sentence anyone to death.
So the judge has to just hit the pause button on the whole trial.
Everything stops. And even after the new law is passed, the defense will immediately file motions arguing about how the new law applies retroactively to their client.
Oh my gosh.
Yeah, it resets the clock on massive portions of the trial preparation.
I have to say, it is like being on a malfunctioning amusement park ride.
How so?
Like you're suspended in the air, you're absolutely terrified, and the mechanics who are supposed to fix the ride and get you down are too busy arguing over the instruction manual to actually bring you down safely.
That is a tragically accurate analogy. That is exactly how the mechanics of capital litigation work. It is designed to be slow and excruciatingly precise.
But in its attempt to be perfectly, flawlessly precise regarding the murderer's rights, the system ends up inflicting a profound secondary trauma on the victim's family.
Yes, it does.
They are trapped. The mechanics of the court are so busy arguing over the instruction manual of the law that they completely ignore the people bleeding out in the waiting room.
We are asking you, the listener, to hold two highly conflicting truths at once here.
Okay, let's hear them.
Truth one. The justice system absolutely must protect constitutional rights and mandate procedural safeguards. Without those, we don't have a justice system. We just have state-sponsored vengeance.
Right. Nobody wants a kangaroo court.
Exactly. But truth two. The uncompromising glacial application of those safeguards causes undeniable emotional devastation to families who just need to close the chapter on the worst day of their lives.
That's heartbreaking.
The system is operating exactly as designed, and yet it is destroying a mother in the process.
Which brings us to the most heartbreaking and honestly the most surprising pivot in this entire story. After 43 months of this purgatory, the endless psychiatric evaluations, the constitutional debates over state law, the total paralysis of the trial, Darlene Farah realized that the state's pursuit of a death sentence was actually a trap.
Yeah, the endless delay forced her into a position where she decided to fight the very prosecutors who were supposed to be on her side.
It's so backwards.
Darlene Farah explicitly stated that she did not want James Rhodes to face the death penalty.
Let's just sit with that for a second. The mother of a young woman who was shot execution style, after handing over the money, stands up and says, "Do not execute this man."
Yeah.
And she is saying this in direct opposition to State Attorney Angela Corey, who is adamantly pushing for death.
It is a stunning contrast. You have the state demanding the maximum possible punishment, and the victim's mother demanding that the state just stop.
Why? I mean, to understand why she took this stance, we really have to look at the psychological toll those 43 months took on her.
We do. Darlene described the weight, the endless legal back and forth, by saying it, quote, took the life out of me.
It took the life out of me. That is so heavy.
It is the reality of living in the shadow of a capital trial. Because every time there is a competency hearing, the family has to go to court. They have to sit mere feet away from the person who murdered their child. They have to listen to defense experts talk about the killer's tough childhood or his IQ score. It completely halts the grieving process. You cannot heal a wound if the legal system keeps peeling back the bandages every 3 weeks to examine it.
So, Darlene Farah took matters into her own hands. She actively began pushing the prosecutors to accept a plea deal. She wanted James Rhodes to receive life in prison without the possibility of parole.
And we need to be crystal clear about something here.
What's that?
This was not a plea for mercy. Darlene was not doing this out of forgiveness or pity for Rhodes.
Right, not at all.
She was fighting for a plea deal out of a desperate, suffocating need for finality.
Here's where it gets really interesting, though. When you look at the mechanics of the death penalty in America, a death sentence is not an ending. It is a beginning.
Exactly. If the state attorney got her way and Rhodes was sentenced to death, the nightmare doesn't end with the gavel strike.
Not even close.
A death sentence triggers an automatic, decades-long appeals process. It starts with a direct appeal to the state Supreme Court.
Okay, so that's years right there.
Oh, easily.
Yeah.
Then it moves into state post-conviction relief, where they argue about, the effectiveness of the trial lawyers. Then it moves into the federal court system, all the way up to the U.S. Supreme Court, through a process called federal habeas corpus.
And what does that mean for the family on a day-to-day basis?
It means 15, 20, sometimes 30 years of legal limbo. It means Darlene Farah would have to spend the rest of her natural life receiving notices in the mail about new hearings.
Oh my God.
Every time a new appeal is filed, it makes the local news. The killer's face is back on television. The details of Shelby's murder are debated all over again publicly.
Versus the reality of a plea deal for life in prison without parole.
Right, because a plea deal is immediate. The defendant waives their right to appeal. The moment the judge accepts the plea, the cell door locks, the key is thrown away, and the man legally and physically disappears from the family's life forever.
No more hearings.
No more hearings, just a locked door.
What this situation really highlights is a profound disconnect between the state and the individual victim. Because in our legal system, crimes are technically committed against the state.
Yes. The prosecutor represents the people of Florida, not Darlene Farah personally. The case is literally titled, "The State of Florida versus James Xavier Rhodes."
And this creates a devastating friction when the state's definition of justice, which, in a capital case is maximum, unyielding punishment to deter future crime, directly conflicts with the family's definition of peace.
It's a clash of priorities.
The state wants a high-profile execution. The mother just wants to sleep through the night without seeing the killer's face on the evening news.
So Darlene Farah became an advocate not just for her daughter, but for her family's right to move on. She had to fight the legal bureaucracy to force them to prioritize her peace over their version of justice.
Which sets the scene for the culmination of this entire ordeal. After 43 months of fighting the defense's competency motions, fighting the changing state laws, and fighting the prosecutor's demand for death, Darlene finally reached the day she can close the book.
We arrive at the courtroom climax, March of 2017.
The final legal resolution was reached. James Xavier Rhodes entered a guilty plea.
He pleaded guilty to a massive slate of charges. First-degree murder, armed robbery, aggravated assault with a deadly weapon, and possession of a firearm by a convicted felon.
And the sentence handed down was life in prison without the possibility of parole.
Which is exactly what Darlene fought for.
I want to make sure the mechanics of this are explicitly clear for everyone listening. By pleading guilty and accepting life without parole, James Rhodes successfully avoided the potential death sentence. The state dropped the pursuit of capital punishment in exchange for the guaranteed conviction. But more importantly, this plea agreement fulfilled Darlene Farah's ultimate goal.
It instantly ended the 43 months of trial delays.
Yes. It bypassed the decades of future appeals, and it gave the family the hard stop they had been fighting for.
The system finally yielded to the mother. But the most powerful moment of this resolution wasn't the reading of the sentence or the signing of the plea paperwork. It was the victim impact statement.
So what does this all mean when you look at the sterile, procedural environment of a courtroom where lawyers speak in statutes and precedents? The victim impact statement is the one moment where raw human reality pierces the bubble.
It really is.
Focus entirely on Darlene Farah in that courtroom. She stood up, she looked directly at the man who murdered her daughter, and she delivered a statement that is absolutely devastating in its clarity.
She looked at Rhodes and said, "You ripped my life from underneath. I cry every single day. I don't sleep."
You ripped my life from underneath. No legal jargon, no constitutional debate, just the absolute devastation of a parent.
Yeah.
And she continued, highlighting the immense relief of this finality. She told him, "For 3 years and 7 months, it took the life out of me. I've been waiting for this day."
I have been waiting for this day. That is the total vindication of her fight for the plea deal right there.
Exactly.
She wasn't waiting for an execution date 30 years in the future. She was waiting for the day he finally admitted guilt, accepted a permanent cage, and let her go.
This raises an important question about the vital, almost sacred function of the victim impact statement in American law.
Think about everything that happened in that courtroom for 43 months prior to that exact moment.
So much talking.
Right. The defense lawyers talked incessantly about Rhodes' constitutional rights. The psychologist talked about his cognitive testing in childhood. The judge talked about Florida state statutes and Supreme Court rulings.
It's a machine.
The entire massive apparatus of the state was focused entirely on the defendant. The victim is often relegated to an abstraction, just a piece of evidence in the daily mechanics of a trial.
But the victim impact statement is the one mechanism we have built into this machinery where the system is forced to stop. The gears literally halt. The legal maneuvering ceases.
And for a few agonizing minutes, The perpetrator, the judge, the defense, and the prosecution are all forced to sit in silence and look squarely at the human devastation they have been managing.
It serves a profoundly cathartic function. It recenters the tragedy on the person who was lost and the people left behind to carry the weight.
It is the only moment where Darlene Farah wasn't just a spectator to her own tragedy. She was the one dictating the terms of reality.
She used that moment to assert that she had survived the murder, she had survived the 43 months of legal limbo, and she was finally reclaiming her life.
It's a testament to incredible fortitude. I mean, navigating the grief of a murdered child is unimaginable.
True.
Navigating it while simultaneously fighting a two-front war against both the criminal and the court system itself requires a strength that is hard to even comprehend.
Well, let's briefly recap the staggering ground we have covered today. We started with a senseless, brutal robbery at a phone store that took the life of 20-year-old Shelby Farah.
We watched a grieving mother immediately pivot to demand corporate accountability through a civil suit, utilizing the mechanics of premises liability to refuse to let a dangerous retail environment go unchecked.
We then navigated a maddening maze of legal delays. We explored how a criminal trial gets bogged down by the rigid requirements of mental competency evaluations and the chaotic shifting of state death penalty laws.
Effectively trapping a family in a 43-month purgatory.
And it all culminated in Darlene Farah's fierce, unexpected advocacy. She fought the state's demand for the death penalty, aggressively pushing for a life sentence plea deal, all to secure the one thing the justice system struggled to provide: finality.
She fought for the right to finally get some rest.
The core takeaway from this deep dive is profound, I think. As a society, we often equate the pursuit of justice with the pursuit of maximum vengeance. We assume that the harshest penalty available is always the most just outcome.
But Darlene Farah's story proves that true justice is highly personal. Sometimes justice isn't about matching violence with state violence. It is simply claiming the power to say, enough.
Enough. It's about taking back control from a system that wants to process you. And as we wrap up, I want to leave you with a lingering question to ponder on your own. It builds on everything we've talked about today, particularly that tension between public law and private grief.
It's a tough one.
It is. When a terrible crime occurs, we naturally assume that the prosecutor and the victim's family are on the exact same team. But as we've explored, the state's vision of justice, with its demand for the ultimate punishment and the decades of appeals that follow, can sometimes morph into a secondary trauma for the family. So we have to ask ourselves, when a family has been shattered and they say they have had enough and they just want the peace of a closed door, should the state have the right to force them to keep fighting for a harsher penalty?
Who truly owns a tragedy?
Exactly. Is it the courts, with their need to send a message to society? Or is it the people who actually have to wake up every morning and look at the empty chair at the dinner table?
It is a question that challenges the very foundation of how we balance the demands of the law with the needs of the human heart.
It really does. Well, thank you so much for joining us on this deep dive. It's been a heavy one, but an important one. We appreciate you taking the time to unpack the mechanics of this journey with us.
Thank you for listening and for grappling with these incredibly complex issues alongside us.
Take care of yourselves, and we'll see you on the next deep dive.